Hello and welcome to this lecture on freedom of expression, underlying principles and sources. My name is Peter Norlander and I'm the CEO of the Media Legal Defence Initiative, an organisation that provides legal defence for independent media, journalists and bloggers who are under legal threat. The right to freedom of expression is strongly protected under international human rights law. The main source for it under modern law is the Universal Declaration of Human Rights, which protects freedom of expression under its Article 19. It's worth reading this provision in detail, since every word and phrase in it has important meaning. Everyone has the right to freedom of opinion and expression. This includes freedom to hold opinions without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. So the right belongs to everyone, not just citizens, for example, or only to some in a country. And it divides into two parts. First, there's freedom of opinion, which may not be interfered with at all. The second part is a freedom to seek, meaning to ask for or to demand, to receive, meaning to get from others, and to impart, meaning to publish in any way, both information, such as facts and reports, and ideas, meaning anything that isn't a fact. Formulated in this way, it is a broad right to express oneself, but also to receive information from others. It has an active component of imparting information, but also a passive component of receiving information. Moreover, the right can be exercised through any media and regardless of frontiers. Although the Universal Declaration was adopted in the 1940s, in the aftermath of the Second World War, this means that it is highly relevant in the frontierless era of the Internet. Article 19 of the Universal Declaration inspired the drafting of the freedom of expression guarantee in other human rights instruments, mainly the UN Covenant on Civil and Political Rights, as well as in the European and American human rights conventions. The principles and structures underlying all these treaties is broadly similar, although the wording is sometimes different. And this means that the lessons learned and cases decided under one of these human rights treaties can often be transposed into others. So why is freedom of expression such an important right? There are many reasons for this. Classic rights philosophy points to the importance of freedom of expression to individual self-fulfillment, to the pursuit of truth in a marketplace of ideas, or, more recently, to guarantee the functioning of democracy. There are also many practical reasons why freedom of expression is so important. It allows individuals to express their opinions. A society in which this is not possible would not be a free society. There will be less corruption in a society where the media reports on the dealings of businessmen as well as government officials. There's going to be less opportunity for corrupt deals. There will be freedom from hunger. The Nobel Prize-winning economist Amartya Sen has pointed out that there's never been a famine in a country with a free press. This is because societies with a free press function more efficiently. Society will be healthier for the same reason, that there's a free press and a free circulation of ideas and everyone is free to report on the mismanagement of resources. There's going to be enhanced respect for the environment, again because information will be available and because of the reporting and ensuing concern for the well-being of the environment. There will be greater respect for other human rights because violations are likely to be reported on. There's even going to be improved national security. It has been pointed out that in the long run, democratic societies are safer countries than dictatorial ones. The political system will be more democratic because the citizenry can make informed choices. The government will be more efficient because its actions are closely monitored and reported on, and suggestions for improvement are made. And for the same reason, there's going to be better decision making, and the economy will run more efficiently. Finally, individuals will receive better treatment from institutions, again because their functioning is open to public scrutiny. It will be noted that most of these are social benefits for society as a whole, not just individual ones. And it is for this reason that the mass media play a crucial role in realizing the right to freedom of expression. This brings into play both aspects of the right to freedom of expression, the active dimension, whereby the media impart information, as well as the passive dimension, whereby the public receives information and ideas circulated through the media. So, when a media outlet is shut down, this affects not just the right to freedom of expression of the journalists who work there, but also the right of the public at large to receive the information that they produce. This has been pointed out by the European Court of Human Rights in cases such as Open Door v Ireland, which concerned the ability of NGOs to provide information on abortion and family planning, and the right of the public to receive that information, whether directly or through the media. The European Court has therefore accorded the media an important status in society, particularly in the context of democracy and political debate. It has often repeated the following phrase: freedom of the press affords the public one of the best means of discovering and informing an opinion of the ideas and attitudes of their political leaders. In particular, it gives politicians the opportunity to reflect and comment on the preoccupations of public opinion. It thus enables everyone to participate in the free political debate, which is at the very core of the concept of a democratic society. This was first formulated in the case of Lingens v Austria, which concerned the conviction for defamation of a journalist who had reported on a debate on how some Austrian politicians apparently belittled the victims of Nazi crimes. This principle has since been repeated in countless other cases and remains a bedrock of European freedom of expression law. So, freedom of expression is important in helping to achieve other human rights, such as political participation, as well as the right to health and food. But what happens when freedom of expression conflicts with those other rights? While freedom of expression is undoubtedly important in the realization of other rights in the International Human Rights Catalogue, it can also come into conflict with them. This is particularly so for the right to privacy, which may be interfered with when a news report touches on issues that, while they're of important public interest, are part of someone's private life. For example, a politician who campaigns against gay rights may have been in a homosexual relationship. The right to respect for one's reputation, which may be interfered with through reported allegations of corruption or bribery. The right to be free from hatred or discrimination, which may be interfered with through reports that place certain minorities in a bad light. Or the right to a fair trial, which may be interfered with through news reports on criminal proceedings that assume the guilt of an accused. Human rights law therefore recognizes that limitations may be placed on the right to freedom of expression, in particular to protect the following: the rights or reputations of others, for the prevention of disorder or crime, for the protection of national security, for the protection of health or morals, for the protection of territorial integrity or public safety, for the protection of the confidentiality of information received in confidence, or for the protection of the authority and impartiality of the judiciary. Now, these are all known as the legitimate aims for which freedom of expression may be limited, and they can be found in paragraph 2 of Article 10 of the European Convention on Human Rights. However, states may not simply impose any restriction on freedom of expression by claiming one of these legitimate aims. Article 10, paragraph 2 of the Convention requires that any restrictions on freedom of expression must comply with what has become known as the three-part test. Under this test, any limitation on freedom of expression is legitimate only if it complies with the following conditions. First, any restriction on a right must be prescribed by law. Second, the restriction must serve one of the legitimate aims that I just outlined. Third, the restriction must be strictly necessary to achieve this legitimate aim. The first part of the test requires that any limitation is prescribed by law. This is simply a statement of the principle of legality which underlies the concept of the rule of law. The law should be clear and non-retrospective. It must be unambiguously established by pre-existing law that freedom of expression may be limited. The European Court of Human Rights has said that to be prescribed by law, a restriction must be adequately accessible and formulated with sufficient precision to enable a citizen to regulate his conduct. The court decided this early on in the 1979 case of Sunday Times v. the United Kingdom, and the principle still stands today. It means that it should be clear how a law will affect the right to freedom of expression of, say, a newspaper, even if that newspaper may need to get advice from a lawyer on the finer points. The UN Human Rights Committee, which is a group of independent experts who oversee the implementation of the International Covenant on Civil and Political Rights, has added that any law that restricts freedom of expression must comply with the principles in the Covenant as a whole, and not just Article 19. This means in particular that restrictions must not be discriminatory and that the penalties for breaching the law should not violate the Covenant. If a law does not fulfill these conditions, then a restriction based on it cannot be considered legitimate. The second part of the test requires that the limitation pursues a legitimate purpose. The list of legitimate purposes for which rights may be restricted in each of the human rights instruments is an exhaustive one. For example, 7 such purposes are listed in paragraph 2 of Article 10 of the European Convention. These are the only ones that provide a possible basis for restricting freedom of expression. A state may not invoke any other reason to limit the right to freedom of expression. If they do, or if they invoke one of the listed purposes but the true purpose is something else, for example to hide corruption, then the restriction is illegitimate. The third part of the test is arguably the most important. Any restriction imposed on freedom of expression must not only be prescribed by law and pursue a legitimate purpose, it must also be necessary in a democratic society. This stresses the presumption that the limitation of the right is an option of last resort and must always be proportionate to the aim pursued. Necessary is a stronger standard than merely reasonable or desirable, as the European Court has held in one of its very first freedom of expression cases, Handyside v. the UK. The law must be precise and accessible, and it must be clear in the parameters that it imposes. In the case of Handyside, the European Court also held that a law may not confer unfettered discretion for the restriction of freedom of expression on those charged with its execution. In deciding whether a restriction is necessary in a democratic society, the European Court considers the public interest in a case. If the information to be restricted relates to a matter of public concern, it would be necessary to demonstrate that it was absolutely certain that dissemination would damage the legitimate purpose identified. The nature of the restriction proposed is also an important consideration. The US Supreme Court has stated that any limitation on freedom of expression must be the least restrictive possible. In the case of Shelton and Tucker, it held that, even though the government's purpose be legitimate and substantial, that purpose cannot be pursued by means that broadly stifle fundamental personal liberties, when the end can be more narrowly achieved. This is broadly the same approach favoured by the European Court of Human Rights. The UN Human Rights Committee has required furthermore that restrictions on freedom of expression may not put in jeopardy the right itself. This is clearly stated in General Comment 34 on the right to freedom of expression. Finally, you should be aware that in assessing the necessity of restrictions, the European Court of Human Rights allows states a margin of appreciation. This means that there is a degree of flexibility in interpretation, which is especially applicable if the restriction relates to an issue where there may be considerable differences among European states. For example, on the protection of morals. The margin of appreciation will be less when the purpose of the restriction is more objective in nature, such as protecting the authority of the judiciary. Having discussed these general principles, it may be instructive to consider how they apply to real-life situations. So let's continue the following scenario. A newspaper, say in a religiously conservative country, publishes a list of names of women who are alleged to have had abortions. The information comes from medical records that have been leaked to the paper by a staff member in a clinic who is opposed to abortion on religious grounds. A number of the women whose names are published sue the newspaper for violating their right to privacy. How should we approach this case? Well, following the three-part test, we should first look at whether there may be a legitimate aim in pursuit of which the newspaper's right to freedom of expression may be restricted. The protection of the rights of others is mentioned as one such legitimate aim, and this would include the protection of the right to privacy of the women concerned. So, there would be a legitimate aim. The second question to ask would be whether there is a law that protects the right to privacy, and whether that law is sufficiently accessible and clearly worded so that the newspaper would have been able to foresee that by publishing the women's names, they might open themselves up to a lawsuit for violating their privacy. The third question to ask is whether the restriction is necessary and proportionate. In answer to this question, more needs to be known about the motives of the newspaper, the situation of the women concerned, and the broader political context of the case. The fact that one of the women is a prominent politician who is well known for her anti-abortion views might be an important factor in this. Now let's look at a second scenario. A newspaper publishes details of the business interests of the Minister of Defence. He owns a shoe factory. He takes the paper to court for breaching his privacy, and he says that his business dealings are his own private affairs. What do you say? Again, this needs to be approached following the three-part test. The first and second parts of this test are the same as in the previous scenario. The legitimate aim protected would be a minister's privacy, and there needs to be a clearly and precisely formulated law under which the minister could sue. And, as under the previous scenario, the third part of the test requires a lot more context. For example, while a shoe factory would appear to be innocuous and have nothing to do with his role as a government minister, it may well be that the factory supplies shoes to the army, and that then raises important questions as to whether a minister should be allowed to profit from business deals with the government department he is responsible for. The previous two scenarios were pretty straightforward. Now let's look at a third. An opposition organisation publishes a series of political cartoons about the president on its website. He's portrayed as an alcoholic and a would-be ruler for life. The prosecutor initiates a criminal inquiry, claiming that the cartoons have defamed the president. If you were the judge, what view would you take? Again, the three-part test will need to be followed. The first question will depend on the laws in force in the country, but let's assume that it is a criminal offence, as it is in many countries, to insult the president, or to insult anyone for that matter. Assuming that the laws in this are clear, that then clears the first hurdle. But what about the second question? Does a restriction like this pursue a legitimate aim? Do you have a right not to be portrayed as an alcoholic? If not, what other legitimate aim would be served by the prosecution? Maintaining national security? Any other legitimate aims? This question would need to be very carefully considered. And how about the third hurdle? Would the prosecution be strictly necessary in a democratic society? We have seen how important the right to freedom of expression is in democracy, and particularly with regard to political speech. Bearing that in mind, will it be really necessary to prosecute? Or would an alternative course of action be for the president to simply respond to the criticism? Respond to speech with more speech? I don't intend to give you the answer here, but these three scenarios hopefully serve to illustrate the approach that international human rights law requires to be taken with regard to restrictions on the right to freedom of expression. I hope you found this a useful introduction to the underlying principles and sources under international human rights law for the protection of the right to freedom of expression. This lecture forms part of a series of lectures that accompanies a manual on defamation law under the European Convention on Human Rights, published by the Media Legal Defence Initiative and the International Press Institute. It can be downloaded from our website, www.mediadefence.org. And I do recommend that you do this and that you use the manual as a reference guide. Do also check out the other lectures, which can be found on our website as well. Thank you for your time.